stated that in the meeting. Well, but other than that, yeah.
That door get me?
I would never have a little bit clear. All right.
Okay, gentlemen of the news media, I want to remind you that there are to be no pictures of the victim's face. I've made that very clear. I'd like to ask you to raise your hand if your channel is live streaming this proceedings today. Sir, do you have a way to put your camera on some kind of delay or something that if the victim moves or your camera gets bumped or something, that you can that quick stop it or something?
I've got it on a 30-second delay, and I'll just make sure that the moves go low.
Okay, please.
So
all right.
it'll be a margin there.
And what channel are you from? 4. Who's from channel 7? Do you have that capability, sir?
I'm not streaming live, as far as I know. I have not before, I'm not sure.
Okay. I'm going to caution you that I've been told you're live streaming.
Okay.
And so I'm going to ask you, do you have a delay?
We're on a delay as well.
Okay, thank you. Anybody else? Who are you?
TV5.
Okay, you're not live streaming. NBC is not live streaming. Where are you from, sir?
12.
12, okay. All right. Have I covered it? Okay. We left off... No, yes, I'm going to be on the record now. We're back on the record in the matter of the People versus Mateen Cleaves, 16T 538FY. When we left off this morning, we were in the middle of the beginning of cross-examination, but Ms. Lindsay was very adamant about an objection she had. She wanted to call, make a call, do some checks. Have you done that, ma'am, before we go any further in the cross-examination?
The court was correct. I couldn't get in touch with anybody. But given the court's limit on that, the one question, I'm comfortable as long as there's going to be no follow-up
Okay,
about that related to other.
well, I'm anticipating there are, so could I ask people, or your crews, whoever, to approach, please? Hmm? Does she?
The transfer comes in, I have the ability to cross, and we're forfeiting that ability.
Absolutely, I agree. Anything that goes. And I Pardon? Yes. And I'm going to put that on our record before. Okay. We're back on the record in Mateen Cleaves. We've had quite a discussion as to anticipated questions, and the prosecutor is quite adamant in her position, and I want to give her the opportunity to put it on the record. And I want to give Mr. Manley the opportunity to put it on the record. They are both aware that the court has ruled, but for appellate purposes, I want to be able to give you the opportunity to put it on the record. So the first thing I want to ask is, Mr. Manley, at our bench conference, was I right in my assumption of the questions that were coming?
Correct, Your Honor.
Okay. Then, Ms. Lindsay, at this time, do you want the opportunity to put your objections on the record?
Yes, Your Honor. It is my position at this time that this type of questioning is not relevant. It violates, in my opinion, the rape shield law as well as Michigan Rule of Evidence 403. The court indicated the court believes it can come in for credibility. My position is that it does not necessarily go to credibility and it's more prejudicial than probative. The phraseology of the question is going to be, and I'm going to cite to the court, Michigan Rule of Evidence 611, which talks about questioning that has the impact of undue harassment and embarrassment to a witness. And I believe that because the foundational issues, the foundational evidence for which the court can make the credibility determination is already on the record. The further questioning on that issue would subject the witness to undue harassment and embarrassment under Michigan Rule of Evidence 611.
Could you give me the specific paragraph in 611?
Yeah. Michigan Rule of Evidence 611A3 to protect the witness from harassment or undue.
I don't have a 611A3. Oh, wait a minute. Yes, I do. I'm sorry.
611A3.
Okay, the rule reads, the court shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to, 1, make the interrogation and presentation effective for the ascertainment of the truth, 2, to avoid needless consumption of time, and 3, to protect the witness from embarrassment or undue harassment. Mr. Manley, would you like to respond?
Yes, Your Honor.
Oh, I'm sorry. I did interrupt you.
Okay, I'm sorry. And in terms of the foundational information which the court has on the record, the court already has on the record the report from Ms. Mose. The court already has on the record the lab reports, and the court already has on the record the answer to that question from the witness. Based on all three of those things, the issue to which the court says is addressed can be adequately, the court can make whatever adequate determinations based on that. The further questioning on that issue, I believe, would be a violation of Michigan Rule of Evidence 611 because it would subject the witness to undue embarrassment. Because her state of what she knows or what some finding somebody else said, that's totally outside of her control. Her answer is going to be her answer, and you already have that answer. So if you're using it to assess whatever you're using to assess, the additional questioning on that doesn't add. And that's why I say it's 403.
Just a moment, Mr. Manley.
Thank you, Judge.
Well, I'll tell you, I'm going out with a bang, ain't I? Okay, what would you like to respond, Mr. Manley?
Judge, there's Wigmore on evidence, there's Manley on evidence, and there's the Michigan Rule of Evidence 402. Relevant evidence is generally admissible, irrelevant evidence inadmissible. You can't have, this is a he said, she said. The prosecutor has put into evidence by their motion that there were 2 male DNA samples found on this woman. They put it in. I didn't put it in. Then their complainant says that she had no consensual sex with anyone within 96 hours. Well, this examination pertained and took place within that 96 hours. So the question becomes, was she lying then? She lying now? And the idea that you should be precluded from embarrassing someone when Mr. Cleaves is sitting over here with his life at stake, his liberty at stake, and me being able to ask the witness, did you in fact tell the nurse? Because somebody's not telling the truth. It's either the forensic nurse or her.
Or there's a third explanation
Maybe it's
out there.
yeah, maybe they made a mistake. I don't know, but I don't have that. I have something. Maybe there's a mistake in the lab report. Maybe there's 3 male donors. I don't know, but there's at least 2. And for me to be precluded from being able to ask that question is absurd. The idea that you can somehow embarrass or humiliate someone when the prosecutor put in a laboratory report that they want you to consider against Mr. Cleaves, which also has somebody else in there, also has a story that she is denied, certainly goes to credibility. The court is not a potted plant up there. The court has to determine the credibility of the witnesses as they testify. Exhibits are designed to help the court determine credibility. So unless those questions are answered, then the court has a hand tied behind its back. Also, and this is important as well, the idea that I would be precluded at this level from somehow asking these very pertinent questions, if somehow this witness was to become unavailable at some future date. That gives lie to the idea that, well, these are questions that should be somehow asked in a different form. It presupposes the idea that the case is going to be bound over and it'll be a jury trial. The first thing that Wayne County will do is stand up and say, well, Mr. Manley had the opportunity to ask these questions, and he didn't. So if she's unavailable, they're going to read it in. So credibility, when you have my understanding, and I think it's going to be crystal clear, is this going to be a he said, she said thing in the room? So the question becomes, all of these other extraneous matters impact credibility. So it is relevant, and it's not prejudicial, and it's probative of credibility. And I think the court's ruling's right on the mark.
Ms. Lindsay, you
Yes.
want to respond to
Yes,
the
just to first of all, to correct a certain mischaracterization of evidence. As it relates to being 2 DNA, 2 male donors, as it relates to the cervical swab, which is all the way in the internal, inside the vagina, all the way up there, the only male DNA was found to be related to the defendant. So the fact that counsel is trying to say that there were 2 donors of I did not interrupt
Well,
counsel.
no, you
I
should
did
not.
No, both of you stop. I held my finger up.
All right.
She's talking.
That's fine.
I'm not going to put up
I
with
said
this.
that's fine.
So as it relates to he said, she said, as it relates to whether defendant Cleaves had sex with her, that's not the issue. The issue is, does the evidence that counsel wants to put on the record add more, or is it merely cumulative? And after counsel's argument about at a higher level, if we would be trying to put the transcript in later, there have been routinely cases at the higher level where the court reviews the transcript and said counsel was foreclosed from pursuing this line, therefore we're not going to let the transcript in. So if it is in fact he should have been allowed to question on that, a higher court can foreclose the people from using the transcript. The issue is right here, right now, does the additional questioning on this issue add anything more? And the court also, under the court rule, has the ability to foreclose questioning that is merely cumulative. It's on the record. She already answered the question. Him asking her or confronting her with what the lab report says about a wipe, which is on the outside of the body, and the other evidence was on clothing, which is also on the outside of the body, I don't think adds anything. I don't think adds anything to the proceedings.
I am now ruling. I will not be interrupted. Under 611C, a witness may be cross-examined on any matter relevant to any issue in the case, including credibility. The judge may limit cross-examination with respect to matters not testified to on direct examination. Let me say this, I have ruled Mr. Manley may ask her if she's aware that there were 2 found. You may ask her that. If she says no, you're all done. You understand? If she says yes, then I want you to slow down your questions, and I'll be expecting Ms. Lindsay to be objecting, and we'll take it up from there. But her answer to that question is relevant to my inquiry as to her credibility. That's my ruling.
Thank you, Judge.
Will you bring in the witness, please? I agree that these are exhibits that the prosecutors put into evidence. They knew what was on there, so they should have anticipated these questions. Well, she said that Is that where she's at? Detective Mary went to get her?
Yes.
Okay. Just so I don't waste her time, okay? Mr. Manley, might as well take a seat and comfortable.
Thanks, Judge.
Okay, we can go back on the record. Ms. Brenda, would you please take the stand? Ma'am, I caution you, you are under oath, and I'm not going to re-swear you because I think you're adult enough to know you're still under oath. I'll be in a little bit of trouble before lunch with you not speaking loud enough. You can try a little harder, right?
Yeah.
All right. At this time, Mr. Manley, you may continue cross.
Ma'am, you remember testifying this morning?
Yes.
You remember testifying on at least 2 occasions in Detroit for what they call investigative subpoenas? Is that
Yes.
correct? You remember testifying on December 9th, 2015?
Yes.
Okay. And you were asked questions about incidents allegedly involving Mr. Mateen Cleaves, is that correct?
Yes.
And today, if I understood you correctly, you said that you ran out of a hotel room at the Knights Inn in Grand Blanc Township or Mundy Township on at least 2 occasions.
Correct.
Okay. And you said that at one point in time, you ran out, you were brought back in, right?
Correct.
And at that particular time, you were sexually assaulted. Is that correct?
Correct.
And I said today that you don't remember any of this stuff and that you'll be getting your information from other people. Is that right?
Correct.
Okay. Now, when you were down testifying under oath in Detroit, you remember Miss Lisa Lindsay, this lady from Wayne County, asking you questions?
Correct. Yes.
All right. And she says to you, and this is on page 24 of the December 9th, 2015. After you run out, she says, well, what happens now when you get back in the room? And you say, I just try to remember trying to run out again. Okay? You remember trying to run out again. Now let me stop you here. We'll go off the record. So, when they asked you what you remembered about going back in and supposedly being sexually assaulted, you said under oath that you don't remember. Isn't that true? I mean, I can have you read it. Isn't that true, ma'am? You don't remember.
I do remember the event in the motel room, yes.
Did you tell the prosecutor that you didn't remember? Read it out loud.
Please tell Ms. Lindsay what...
Page 24, lines 14 through. Read them out loud and tell me what you said.
She asked when I got back in the room if I was crying. I said I didn't remember if I was crying or not. Not whether I was assaulted, whether I was crying.
What does it say that you don't, what? Read it out loud.
I don't remember now. I believe I was, but I don't remember now. So what happens now, I just remember trying to get back up, trying to run out again.
It doesn't say one single word about being sexually assaulted, does it?
Your Honor, I'm going to object under the Michigan Rule of Evidence 106, the Michigan Rule of Completeness. I can have, as an adverse party, the entire thing put in to put everything in context. I can read the court rule, because if you can take isolated parts out of context.
There's nothing out of context, and that's not an appropriate objection. She can...
Let her finish. I'll give you your chance.
That's fine.
Michigan Rule of Evidence 106. Remainder of or related writings or recorded statements. If a party introduces all or part of a writing or recorded statement, an adverse party, which would be me, may require the introduction at that time, which is now, of any other part or of any other writing or recorded statement that it ought in fairness be considered at the same time.
Mr. Hammond?
Yeah. I mean, the absurdity and the idea that someone would have, I give it credit for audacity. This question that I asked and had read in was on December 9th, 2015. The prosecutor from Wayne County didn't get the answer she wanted at that particular time, stopped the proceeding, stopped it, and said, we will go no further. Sent her back to reread notes and then brought her back on December 15th. The idea of somehow completeness, she stopped it, sent her to review supposedly some other notes or talk to Marion or talk to whomever. I mean, it's ridiculous that she would, I mean, Judge, I gave appropriate question. She made an objection. She made an objection on completeness. And on completeness, where she stops her own witness, starts the next investigative subpoena with, have you had the opportunity to review your notes? She takes almost, what was it, from the 9th to the 15th, almost a week, I guess, to complete it.
Your Honor, his argument does not address the sum and substance of the rule.
It certainly does.
Which the rule indicates that if something is not complete, which is clear, it was not complete, then you have to, in fairness, consider the entire thing. So what I'm saying is you cannot take it out of context like that, according to the Michigan Rule of Evidence, Rule of Completeness.
So what is it that you want me to do, Ms. Lindsay? Read the whole transcript?
No, he has to refer to the portions in the transcript after she had said she had an opportunity to review it and put those portions in, because the reason behind this rule is so things cannot be taken out of context. She
So
said
how much more do you want him to put in?
he needs to put in the part where she indicates she had an opportunity to review her statement and she remembers what happened. As it relates to it, in which you also have to remember, the investigative subpoena transcript proceeding was held several months after the incident.
I understand that.
Okay, so according to the rule of completeness, he has to refer and put in at this time the portions where she says she does remember.
Go ahead and put it in, Mr. Manley.
Did you go back and talk to Mr. Narian? Did he tell you what to say a week later? Did you review some other notes?
Your Honor, the way it has to be done, if you're using the transcript, because you're using the writing, you have to do
Okay, but wait a minute.
because he
Just a minute. I have a question for you. In your response to this, you said he has to refer back, and you said she went back and she reviewed notes.
correct.
I don't know whose notes. I don't know that it's relevant that I know whose notes. So far, that's all he's asking her. Did she go back and review notes?
I know, I understand that, Judge, but the rules of evidence says he puts the statements in their proper context. Then if he wants to go and ask those questions, because the rule is clear, he has to do it all at one time. Then he can go back and
He's trying, ma'am, and you keep interrupting.
No, because he did not refer her to the specific page
Refer her to the
in
specific page.
the second transcript where she did in fact say those things happened.
She's blurring the lines. What I referenced was before, and now this is rule of completeness. As soon as she said, okay, you remember, this is her question, Miss Lindsay, okay, you remember trying to run out again, now let me stop you there, now we can go off the record. That's the complete.
Is that the complete
That's complete. The next one's an entirely different entity.
Nope, but you have to listen to what the rule says, Judge, and
Judge.
I'll read it again.
I have the rule right in front of me. When a writing or a recorded statement or part thereof, am I correct,
Yes,
is introduced by a party,
yes,
an adverse party may require the introduction at that time of any other part or any other writing or recorded statement which ought, in fairness, to be considered contemporaneously with it.
and it does,
This transcript stops.
right, but
Now, if you want him to pick up the December 15th transcript and read in, has your memory been refreshed, did you read your notes, he can do that.
But just, I think both of you are talking about the transcript stopping, and that is not the determiner according to the rule, because it says, or any other writing.
That's why I'm referring to the
Okay.
second transcript.
And you
Okay,
said
so-
may. May I go on?
Yes.
Thank you.
Now, let me rule on the rule of completeness.
Okay.
Okay, objection. In order to satisfy that rule of evidence, I would like you within the next few questions to pick up the second transcript and complete the train of thought that you have.
Well, my train of thought, Judge, is that I will go back as we go. This is a separate statement. My train of thought is as I cross-examine, I will go back and I will probably read into the record where Miss Lindsay tells the witness, have you had the opportunity to review all of your notes?
No, you won't probably, you will, because that's how this second transcript begins.
But I'm going on now to ask other questions because
No, I want this asked now so that the rule of completeness is taken care of. I'm trying not to interfere with your cross-examination, Mr. Manley. I know you have a style that you like to adhere to, but
I have no problem.
Thank you.
I'm not going to do her job, but I have no problem saying, here, this is on Tuesday, December 15th. How many days later? 6 days later. Miss Lindsay, today's date is December 15th, 2015. We are back on the record from investigative subpoena that was started on December 9th. We broke last time in order to allow the witness the opportunity to review the transcript of her previous statement. Now, I can't, that doesn't even, number one, were you down there?
Yes,
Did they stop it?
yes,
Did they make you come back?
yes,
Did they have you review statements in between?
yes.
Mine doesn't even say which statements they reviewed. So I'm going to move on.
Okay.
Thank you. Ma'am, you would agree with me, regret's not rape, is it?
Objection, Your Honor, question argumentative. That is an argumentative question.
Could you rephrase it, Mr.
Sure. Ma'am, you weren't forced to do anything here, were you?
Yes, I was.
You were? Okay. We're gonna take it all the way through. You worked at the Whaley home, right?
Yes,
And you were, what'd you say, an administrative assistant, is that correct?
correct.
And you worked there for how long?
Approximately a year and a half at the time.
And you were with Holly High School, you're a graduate of Central Michigan University?
Yes.
Is that correct? And what you basically described in your statement is that basically you did anything. You were like kind of a gopher at that event. Is that right?
For that event, yes.
And you were drinking at that event, right?
Correct.
And you were drinking alcohol, is that right?
Correct.
And one of the things you said earlier today was you were concerned about your behavior reflecting poorly upon you so that you could keep your job. Isn't that true?
No, not my behavior. Rejecting Mr. Cleaves,
So you knew
reflecting poorly on
you
my
didn't
job.
want the person that you accused of being raping you, you didn't want him to look bad to the Whaley home? Is that what your testimony is?
No,
You didn't want him to look bad, right? That's what you've already said, right?
But, Your Honor,
That's not what I
objection,
said.
mischaracterization. She did not say that.
I want to hear her answer. Your
That's-
objection's overruled.
that's not what I said. What I said was, I did not want rejecting him and him making some type of complaint affecting my employment or losing his support with the agency.
So you didn't want, you were worried that Mr. Cleaves may make a complaint against you, right?
If he had a problem with me
Well-
rejecting any advances, yes.
Well, certainly, why wouldn't they believe you?
Objection, Your Honor, question is argumentative.
Why in the world,
Objection, question is argumentative.
Overruled.
why in the world would anybody think that you had done something wrong?
Objection, speculation. Objection, speculation.
No, it's not speculation, Miss Lindsay, because she's the one that thought it. So we need to know the basis of the thought. And it was her thought. It's overruled. Go ahead, Mr. Manley.
Ma'am, why in the world would you be concerned about Mr. Cleaves saying something about you unless you knew you in fact had done something wrong?
Because that puts it as a he said, she said situation with my employer.
How is this not a he said situation?
Objection, question, argumentative, Judge.
Overruled.
Ma'am, you said you were in a hotel room with Mr. Mateen Cleaves, is that correct?
Correct.
Take your time and be very careful when you answer this. Who else was in that hotel room?
No one to my knowledge.
So you, in fact, by your own testimony, have a he said, she said situation, do you not?
Objection, that question is argumentative, Judge.
Overruled.
By definition, you're in the hotel room, correct?
Correct.
You say Mr. Cleaves is in the hotel room, correct?
Correct.
So by definition, it's just you two, correct?
Correct.
So it's your word versus Mr. Cleaves' word, by definition, is that correct?
Objection, question, argumentative, Judge. That question.
I won't allow the argumentative, but I will allow an asked and answered.
Thank you.
So you worked at the golf outing, is that right?
Correct.
And you're drinking. You had never met Mr. Cleaves before, right?
Right.
And you were an athlete at Central Michigan. Was it soccer, lacrosse, what was it?
I was not an athlete at Central.
Where did you play? What did you play?
Objection, Your Honor, relevant.
It goes to the relationship. I can flesh it out. In fact, I can even withdraw it at that point.
Okay, withdraw it at this point.
That's fine. Who was the celebrity guest at that golf outing?
Mr. Cleaves and George Blaha.
Okay.
Excuse me, I can't hear you.
Mr. Cleaves and George Blaha.
Counsel, is it important for me to know who
George Blaha is the voice of the Detroit Pistons and also is the Michigan State announcer. He's well known in
I just
announcing.
asked if it was relevant for me to know. But now that he brings it up, I know who he is. Go ahead.
Okay. So you get there at 10 o'clock, is that right?
Get where?
In the morning, Warwick Hills.
No, I was there earlier.
So you were there all day, right?
Correct.
All right. What did you eat lunch?
I ate lunch, I don't know what time I ate lunch.
Okay. When did you start drinking?
After the golfers went out, the Whaley staff had a beer at noon, but then I did not have another drink until dinner, which was around 6.
Why in the world that you're staffing something and you're on the clock, right? You're a professional, correct?
Correct.
You're representing Whaley Home, is that correct?
Correct.
And you're drinking on the job, is that also correct?
Correct.
Okay. Had your supervisor given you permission to start drinking alcoholic beverages while you were on the job?
Yes, my supervisor was there.
So everybody working at the Whaley Home, I'm sure the board were drinking during the golf outing while they're working?
Not everyone.
Well, tell me why you were allowed to drink.
Judge, relevant. Whether she was drinking, whether she had permission to drink or not, relevant.
What's your relevance, Mr.?
It goes through one continuous, she segues from drinking at the golf outing in the morning now. Now then she's going to drink at dinner. Then she's going to drink at the...
I've got all those.
Yeah, so it's relevant.
You brought them out on the record.
But the reasons why, whether she had permission or not, how is that relevant? If she had permission or didn't have permission, how is that relevant?
Credibility.
It does not, that is just an improper character evidence.
Judge, I can move on. There's so
Move
much
on.
stuff
Thank
here.
you.
It doesn't even matter.
Move on, Mr. Moore.
Thank you. Tell me about who you asked first to have your picture taken with Mr. Cleaves.
I think I just asked for a picture. I
No,
believe I asked him.
You didn't. You went over and asked Dawn Wisner, did she know Mr. Cleaves? Isn't that right?
No. that's
Who
not
did
correct.
you ask? Because you didn't just go up to Mr. Cleaves.
Brooke Adams and I had been talking. She had mentioned that she was going to invite him.
No.
Your Honor, I'm going to
No.
object.
Wait a minute, I think there's...
The answer's non-responsive.
I think there's
Yeah.
some confusion.
I'll tighten up the question.
Yeah, because I think the witness is confused as to what time period you're asking.
Right. I'm talking about when you're at Warwick Hills, before any of the field trip to Sweetwater. You're at Warwick Hills, and you want to meet Mr. Cleaves, don't you?
I did not ask for an introduction, no.
You, in fact, not only asked for an introduction, but you went and asked somebody to take your picture with him.
I did ask for a picture, but I did not ask for an introduction.
So you took your picture with no introduction? What did you do, just walk up and just stand there and have somebody take your picture without, that makes no sense.
Your Honor, I'm objecting to the editorial and the commentary. That's not even a question, that's
Tighten it up,
commentary.
Mr. Manley.
You didn't just walk up to Mr. Cleaves and have somebody take a picture, did you?
No.
In fact, you talked about it, right?
We had had a conversation, yes.
Who'd you have the conversation with?
Who's we?
Brooke Adams, myself, and Mr. Cleaves.
Who took the picture?
I believe Dawn Wisner.
So Dawn Wisner, and the picture was for you, right?
Yes.
You took your picture with Mr. Cleaves, right?
Yes.
Okay. And then, was this at the dinner?
That was after the event while we were cleaning up.
Okay. And this is, you said you had the proverbial, you didn't say 2 beers, you had the proverbial 1 beer in the morning, right?
Correct.
And then you had the proverbial, not 2 beers, but 1 beer at
Your
dinner.
Honor, I'm going to object to mischaracterization. She said at noon, he's changing it in the morning. If we're going to use the testimony, can we use the testimony and not mischaracterize the testimony? Thank you, Judge.
So you drank again, only 1 beer each time?
Correct.
Is that what you're saying?
Yes.
And then you say that you got a picture with Mr. Cleaves.
Correct.
He didn't approach you, you approached him,
Correct.
right? And then you said you're cleaning up, and about sometime around 10 o'clock, a group of Whaley Home employees decide to go to the Sweetwater bar, cafe, restaurant. Is that correct?
Correct.
And that's the further party, is that right?
To celebrate a successful event, yes.
Celebration party, whatever. Same thing, correct?
Correct.
Is that right?
Yes.
Okay. You were a little coy when Miss Lizzie was asking about it.
Objection, Your Honor. Commentary, if he's going to ask a question, his editorializing and commentary is improper.
I can move on to it. The fact of the matter is, ma'am, you got your picture taken with Mr.
You're
Cleaves.
making a reference to a page, ma'am.
I haven't made a reference to anything. You have the opportunity to get your picture taken with Mr. Cleaves, is that right?
Yes.
And you went over and talked to Mr. Cleaves, is that right?
Yes.
And so forth. Now, when, at that particular juncture, did you type Mr. Cleaves' number into your phone?
We had been discussing how my sister goes to state.
Your Honor, I'm going to object. He
No,
asked
I'm
away
not,
the question.
no. I'm going to tell you what, Miss Lindsay, if I don't let him ask the question, I'm going to ask the question myself, because she testified on direct that she had not met Mr. Cleaves, and then she testified, she texted him. One of the questions this court had was, how did you get his phone number? I'm going to allow this question.
No, I wasn't objecting to the question. I was objecting because she started to answer and he was interrupting her. That's what my objection was, Judge. You didn't even let me get it out. She started to answer, and then Mr. Manley started to interrupt her. I wanted her to be able to get her answer out before the interruption came.
It was non-responsive. She talked about her sister, so every question. Oh, sorry. Ma'am, you indeed got Mr. Cleaves' phone number. You gave him your phone number.
No, he offered his phone number to me.
He offered his phone number to you.
Yes.
Can you show me here? And I'm
Wait a
gonna show
minute, Mr. Manley. Whatever you've got in your hand, you show it to Miss Lindsay.
You got it. I got it from them.
Oh.
I understand that might be true, Your Honor, but
All I said was he had to show it to you.
Yeah.
I didn't make anything else about it.
okay.
I've referenced it. She's got it on top.
No, I just want to make
No,
sure.
then just sit. Hand me my copy.
Excuse me, Judge. I want to make sure that there's nothing on here that shouldn't be on here, or that there's something on here that should be redacted. I need to look and make sure. And that's...
You may look at it, Miss Lindsay.
Thank you.
What he's asking you is, because you're sick, could you not be fondling it?
Well, I mean, good Lord. Judge, I don't think I have to let them have a conference on.
No, you don't.
The fact of the matter is,
Oh,
ma'am,
my.
For the record, Mr. Manley just took two of the three.
I saw it.
Thank you.
You
Third
can
one's
get
still in my
it.
hand.
Third
You
one.
missed it.
thank you. I appreciate my having my things that will be looked at
Just
in
go
my
on.
cross-examination. Can I ask you, ma'am, you're going on your way to Sweetwater, is that right?
Yes.
I said party, you said to celebrate, is that right?
Yes.
And that means you were going to drink, is that right?
Yes.
And you in fact did drink there, is that right?
Correct.
And you started again, I think you said again, 1 beer. Is that right?
At Sweetwater?
Yeah.
Is that, yes.
So you had, every time you drink, just coincidentally, you have 1 beer, is that right?
Yes.
Okay. Now, when you get there, and you said it was about 10 o'clock,
Approximately.
when do you contact Mr. Cleaves?
Shortly after we had, the Whaley people had gotten to Sweetwater.
Well, was it in response to Mr. Cleaves texting you?
No, as a group, I was asked if he was coming, or we were asked, discussing if he was
Can you
coming.
read those text messages to yourself, please?
Mhm.
You guys be careful.
Mhm.
Have you had a chance to read them?
Mhm.
Is that a yes or no?
Yeah.
Now, you just said you basically didn't even talk to Mr. Cleaves. Somebody gave you a picture. You kind of gave the impression that you didn't even really know Mr. Cleaves or hadn't had much conversation with him, right?
No, I said there was a conversation prior to the picture being taken.
What did you talk about? How long? When?
We had talked about my sister who attends state. We talked about the Central Michigan University versus State football game that was coming up sometime later that month.
So you guys had established, you had established some rapport.
And acquaintances.
Oh, great. So you had established a rapport at that point. Is that right?
Your Honor, that she asked and answered. She said, he asked her, had she established a rapport? She said acquaintances, and then he asked the question again, objection, asked and answered.
Okay, I'm going to sustain that objection, but I'm going to follow it up, okay, with my own question. She said that he became an acquaintance at that point. Which point are we talking about? Before the picture, after the picture, Sweetwater, what are we talking about?
I think she's talking about, it's unclear, that she's talking about while they were still at the golf outing dinner, is the way I understand the question. Is that correct?
During that conversation, or yes.
So you're still at the golf outing, correct?
Correct.
And then about you leave, right?
Yes.
And you send Mr. Cleaves a text message that says, "This is Emily from Whaley. Thank you so much for everything," right?
Right.
Mr. Cleaves doesn't reach out to you. You reach out to Mr. Cleaves, right?
Correct.
It says, "Hey, we're at Sweetwater. Hope to see you here," right?
Correct.
So you invite Mr. Cleaves to the party where you're drinking, correct?
He had already been invited.
Well,
That's non-responsive.
yeah.
I
There's
followed
nothing in
up
the
a
text
verbal.
messages that say that, is there, ma'am?
I followed up the verbal invitation with a text.
My question to you, ma'am, is there's nothing in the text message.
Correct.
Mr. Hanley, what was the second text? We are at Sweetwater, what?
We're at Sweetwater. Hope to see you here.
Thank you.
And then Mr. Cleaves responds, "Be there in 20 minutes." Is that right?
Correct.
And you say, "Okay, good," with a happy face emoji.
Correct.
Mr. Cleaves at some point in time says, "You guys still there?" Right?
Right.
And you say, "Yeah, you should come," right?
Right.
So the idea to come to Sweetwater, there's no record of any earlier invitation. The only invitations that I see by way of record, and maybe you can correct me if I'm wrong, but the only thing that I see here are the texts to you to Mr. Cleaves, right?
Objection would cause her to speculate whether there was no.
No, it doesn't, because she testified earlier that there had been an invitation by someone else made in her presence. So it's not a speculative answer. She knows the answer to that. She's already testified to it.
He specifically about a record, not a conversation. She talked about a conversation. He asked her about a record.
Okay, that would be speculative.
And that's what I was objecting to.
That's speculative.
Thank you.
Ma'am, did you see any of these other people? Because you keep saying "we," and all I keep saying is "you."
Objection,
So-
Your Honor, to the objection to the form of the question. He has a question he can answer. That is an improperly formed question. That's editorializing.
Please question her.
Yeah. That was proper. You didn't see anybody else text Mr. Cleaves, did you?
Not to my knowledge.
Right. So when you say "we invited" by way of text message, that might mislead somebody because the only person that text messaged Mr. Cleaves was you, right?
That she knows about.
That I'm aware of.
So at some point, Mr. Cleaves gets to the Sweetwater, is that correct?
Correct.
And you start drinking with Mr. Cleaves, is that correct?
Correct.
And you said that you had beer before, is that right?
Yes.
Then you said you started drinking shots, is that right?
Yes.
And you said you started drinking lemon drop shots, is that right?
Yes.
How many?
2.
2. And how many, what, do you have some Ciroc? What was the other shot you said you drank?
There was 2 lemon drops and 1 shot of tequila.
Okay. And you said Brett Warner brought the shot of tequila, and that's another coworker of yours?
Yes.
Mr. Manley, Miss Lindsay, would you both help?
Thank you. So you're drinking when you're at the Sweetwater, is that right?
Correct.
And at some juncture you indicated that you had talked or you gave an interview with Detective Naring, is that right?
Correct.
That's this gentleman over here.
Yes.
You can see him right here. That's him, you know him?
Yes.
Okay. Then that was on September 17th of 2015, is that right?
Yes.
And that was at the Munday Township Police Department?
Correct.
Is that correct?
Yes.
And that's the one where you told Detective Naring, so I have to go through this, I have to go through the whole story for the third time now? Page 2, line, there isn't a line. Did you tell him that that was the third time you had to tell the story?
Yes.
And he told you that I'll wait for my parents to get here? Remember him telling you that?
Yes.
Your parents?
Yes.
Okay.
Who said they'd wait for the
Mr. Naring.
Your Honor, at this juncture, I'm going to object to the use of the transcript because reading from the transcript without any purpose is hearsay. He's not using it to refresh. He's not using it to impeach. So he's just reading off things from the transcript, which is hearsay. It has to be a specific purpose for being done. Objection.
Why are you reading off the transcript?
I'm just, because it's probably when she jumps up, I can paraphrase and just say, isn't it true? Which is a proper
So
direct.
you're using it as your own outline of your cross-examination?
Yeah.
As long as that's all you're using it for, I don't have a problem.
That's fine. So when you were over there, you'd already talked to at least 2 people? Would that be the police? Would that be the nurse? Who would the 2 people be that you had talked to before you talked to Naring?
Once with the nurse and once with the police.
Okay. When did you first talk to the police?
After the exam at the hospital.
So if the police officer said that he talked to you at the Knight's Inn, he would be mistaken or being untruthful?
Your Honor, I'm going to object once again. You cannot have one witness comment on the testimony of another witness. What is the relevance of her commenting on the testimony of another witness?
Commenting on her own testimony is a very common question in cross-examination, and I'm going to allow. She's not testifying as to whether this hypothetical officer was lying or fabricating. She is testifying as to whether she would think that answer would be a lie or an untruth, and I'm going to allow.
Okay, but can I further?
For the record, you can put anything
Yes,
on you
for
want.
the record, I want to know, why is what she thinks about what somebody else says relevant? Why is that relevant? What relevance does it have? Remember, relevance goes to the charges. Whether she thinks the person is lying or telling the truth, how does that aid in the determination of probable cause?
In this particular case, it goes to her ability to remember places, events, and chronological order of those. She is saying the first time she talked to the police was at the hospital. This court has reason to believe, based on videos that you put in, that there might have been an earlier time, and I'm going to allow this question.
Well, then the question is, he only gave her 2 choices. The question is, do you recall talking to the police officer? Not if this officer said this, he would be this, that, and the other. That's still...
I'm going to allow that question.
Thank you, Judge. Ma'am, if somebody came in and said that you, a police officer, a 20-year police officer, veteran, said that he talked to you at the scene, would he be either not telling the truth, you have no idea?
I don't recall talking to the police that night.
Now, when you talked to the police, was it a professional interview with Detective Nearing?
Yes.
Excuse me, Mr. Manley. For the first time, I'm interrupting instead of Ms. Lindsay. You're going to have to define for this court what you mean by a professional interview.
Well, maybe my next...
Was she Mirandized?
No, my next question will say that.
All right.
Do you recall Detective Nearing saying, "I'm on your side, okay"?
Yes.
So before, that's the first time you talked to him, right?
Yes.
So he's already telling you before he knows anything about Mr. Cleaves' situation that he's on your side.
Your Honor,
right?
objection as to relevance.
Bias, prejudice, and motivation.
That might go to that witness when that
Goes to that witness only. But yeah, it's bias, prejudice, and everything else, but only as it relates to that witness if he's called.
right.
Okay.
Did you tell Detective Nearing that you didn't want to tell everyone, again, that you didn't want to tell 6 people that you had already told your story?
Yes.
And your mom and dad were in the room at that particular time?
Yes.
So if the police officer at the scene, contemporaneous, when this supposedly happened, said you were never assaulted, your mom and dad weren't there at that particular time, were they?
Objection, Your Honor. This A, assumes facts not in evidence. Question hypothetical. Question argumentative.
Okay. As to, what was the first one?
All-
Assumes facts not in evidence.
That's true. Sustained on that. What's your other two?
Assumes facts. If you sustained it, then he has to ask another question.
No, because there was a 3-part, and I'm going to sustain that it assumes facts and evidence.
Well, then my objection is compound question. You can't ask compound
That
questions.
I'll allow. Re-ask your question.
Thank you, Judge. Did you tell, in fact, that to tell Detective Nearing that you have experience with this type of situation, professional experience on the other end, that you were some type of counselor?
Objection asked and answered.
No, it wasn't asked and answered, and I'm going to allow the question.
Yes, I have professional experience.
In rape
That
counseling?
wasn't the question. The question is, did you tell Detective Nearing that you had experience?
Yes, I told Detective Nearing.
Did Nearing tell you that he gives you a lot of credit for standing up for yourself, and it frustrates him when people don't?
Objection, Your Honor. Relevance.
Goes to the bias, prejudice of any testimony that Detective Nearing might be giving, and I take into account the detective's position professionally at the time this interview is being given. So,
Once again, can I further? This is a probable cause hearing. It is
oh
not.
really? You finally realized that?
No, I've known it from the very beginning, Judge. This is a probable cause hearing. And although these issues may come up at trial, specifically, and Judge, I'm sorry. I'm just trying to do my job.
And you're doing a wonderful
I'm
job.
just trying to do my job. And I understand that sometimes the court gets frustrated with me, but I am an advocate. I am trying to do the advocacy that I do with the rules of evidence in the law. I am not trying to upset this court. I am not trying to frustrate this court. So, by saying that it is a probable cause hearing, there are issues that may be germane further on down the line. So asking everything about Detective Nearing, who I am not planning to call, and counsel did not indicate he was going to call, I think goes far beyond the scope of what we're going to do, what we're supposed to be doing here, and that is why I'm objecting. I'm sorry, Judge, if I'm upsetting you. I don't mean to.
You're not upsetting me, and I'm not frustrated. Trust me, Miss Lindsay. I have more important things in my life going on than this case, just like the Wayne County Prosecutor's Office does, okay?
Okay.
Much more important things. However, one of those things that this court judges in its probable cause is a witness's credibility, continuity, and I believe I have a right to hear these things, especially from this witness, knowing full well that if something unforetold should happen and this witness is unavailable, this transcript will be used. I am not frustrated with you, ma'am. You've been excellent today. What do you want, Mr. Muscat?
Hello, Judge. I'd like to place on the record that, as the court well knows, you instructed the audience to remain silent during these proceedings, and after your last, it'll show up on audio.
I'll control my courtroom. Thank you.
For the
Go ahead,
record, somebody
Mr.
was
Manley.
clapping, Judge.
Thank you.
I said I'd control my courtroom. Go
Thank you,
ahead, Mr.
Judge.
Manley.
Thank you. I asked you a little while ago about the meeting with Mr. Cleaves and how it came about, and you were said, well, some of us wanted to meet him or something to that effect. I wasn't quite sure. Would that be accurate? How you came about meeting Mr. Cleaves?
Objection asked and answered, Judge. This area about how she first came in contact with him has been asked and answered.
I'm going to clear it up.
You better clear it up.
I'm
because
going to.
I don't even know how to answer her objection. Okay?
Yep. It says, now Mr. Narian says to you, okay, so how did you meet him? And you say, I just introduced because I knew who he was. I did want to meet him, so you were the one that introduced, you made the move for the introduction.
I was introduced by another Whaley employee.
At your wish.
Yes, he's our celebrity guest. He's supposed to be a big deal at the event.
Okay. And you say down here, and you've said it here today, that he's a big donor. Tell me exactly how much, and be specific, how much he donates to the Whaley Children's Center.
I don't know how much. I know he does do, or he has in the past done shopping sprees and that type of things with our kids.
Well, the reason I ask you, when you say he's a big donor, that gives the impression that you have inside information.
Your Honor, I'm going to object to his constant editorializing. He can just ask a question. Why he thinks she thinks of certain things is not germane. He can just ask a question.
Overruled. Go ahead,
Thank you.
Mr. Manley.
Ma'am, you were the one that used the adjective, he's a big donor, right?
True. Yeah.
Tell me how much money?
I don't know how much
How
money.
many
Objection, Your Honor. Ask the answer.
He hasn't even got the question out.
He asked the question. She said, tell me how much money. She said she doesn't know. And he's asking another question. She doesn't know.
You don't even know what he was asking about. Overruled.
Thank
Go
you.
ahead, Mr. Manley. Now you're beginning to frustrate me.
You said shopping spree, right?
Correct.
So how much on the shopping spree?
Objection, Your Honor. It's irrelevant. She
It
said
goes to whether or not she believes he's a big donor.
I'm not aware of how much money that he spends during that shopping spree, but I know previously was a big event for our children.
My point being, you say big, but you really don't know, do you?
Correct?
So it's an adjective that you use, right?
Yes.
You don't know if it's $1, if it's
objection is to relevance, Judge. She's already established she don't know, so to go furthering on this line, ask and answer. He's already explained the scope of her knowledge. She says she doesn't know.
May I answer, Judge, if
No,
I need
because
to?
I have already ruled on this. I'm going to tell you. She went to her state of mind, and she said she was concerned about if Mr. Cleaves reported any rudeness on her part back to Whaley, that she might get chastised, reprimanded, fired, whatever. Her state of mind as to what she thought how big he was is relevant into how she governed her behavior.
Thank you, Judge. So when you say those things, a big donor, you're guessing. You don't know, do you?
I know that what he does do is greatly appreciated by the agency.
I understand that, ma'am. But when that's
Wait a minute, Mr. Mann. You're getting her, trying to make her give an answer that She has said numerous times she can't give. Maybe you'd be better off asking her to define what a big donor is.
What is a big donor to you?
When it comes to events and those types of things, I guess somebody whose name or a organization whose name comes up, that they help us out quite a bit.
So it goes more to the name than to anything about money.
Correct.
And you use that term, big donor, of your own volition. Nobody told you he's a big donor.
Correct.
Now, when you were at the Sweetwater, you were drinking, is that right?
Yes.
And there was at least one board member from the Whaley home there, is that correct?
Yes.
Fred was there. Do you remember Fred's last name?
Not at this time. I can't recall his last name.
Stop. You adjust that camera right now.
I'm sorry.
You adjust that camera right now. Now, I want it down. Not that far. Too far up.
I'm on a tight shot.
I can't see that. All I can see is where the camera is. Go ahead.
That'd be Fred
Just wait
Hensler.
till we get on the record.
Okay.
Go ahead, Mr. Mann.
That'd be Fred Hensler.
Correct.
Would you spell that for me?
Yes. Hensler, last name, first name, common spelling, Fred, Ferd. And you were concerned about Mr. Hensler because you were drunk at the bar, right?
Not while he was there, no.
What's a lemon drop?
It's typically a shot made with vodka and lemon juice or lemonade, some type of combination like that.
And you said that, how much did you have to drink at Sweetwater? I've asked you that a bunch of times, but there's a method to my madness. You told Detective Nearing when he asked you how much you had to drink at Sweetwater, you said you had 2 beers.
Yes, I had one prior to Mr. Cleaves getting there, one when he got there.
And then it says here 3 lemon drop shots, not 2.
Your Honor, if he's going to impeach, I would ask the impeachment to be done specifically with page references.
I have no problem.
He has no problem with that. You're correct.
Page 16 of the draft account of Detective Nearing.
Date
Near the bottom, there's no lines.
9/17.
I don't know.
I was getting the date. Page, please.
16. It says here, so you had 2 beers of Sweetwater, then I think there were 3 lemon drops and a shot of tequila. That sound right?
Sounds like the statement I made at the time, yes.
Well, it's clearly a statement you made. I said, does it sound right?
Your Honor, I'm going to object under the rule of completeness under page 17. I asked to go over on page 17 where the witness clarifies and said 2 lemon drops. That's the rule of completeness.
Okay, I'm not worried about the rule of completeness. What I'm worried about is where are you getting this from? Is it the very next page?
He read her something on page 16. The very next page on page 17 when the witness is explaining. And it's my understanding if you're going to be using the transcript computer, you have to do verbatim what it said, not paraphrase.
The fact of the matter is, there's 2 different statements. It goes because she's making my case. There's 2 different statements. I'll move on. It's obviously said at least 2 different things. So obviously it's not the same.
Your Honor, can I have a ruling under the rule of completeness?
Under the rule of completeness, he would have to go through the transcript at least to where she corrects herself, remembers, whatever.
Correct.
At least as to the number of drinks.
Yes, and that's halfway down on page 17.
Okay. So for the record, she corrects herself on page 17 and goes back to 2 lemon drops.
Correct.
It-
But
either
but it has to come from, it just can't be us agreeing, it has to either be a stipulation or it has to come from the...
Later on, you change and tell Detective Nearing 2 lemon drops?
Yes.
Yeah.
Yes, thank you.
I'm flummoxed, but the fact of the matter is it can be corrected or contradicted, but I'll move on. It says here that you don't ever remember getting into the car with Mr. Cleaves. Is that correct?
Your Honor, well, I hate to be a stickler, but he's reading off, he has to ask her a question first because before he can foundationally read off what is on the statement. That's the way it works.
I would agree, because I asked him earlier, I said, Mr. Manley, are you just using that as an outline for your cross-examination? And you said yes. I didn't have a problem with that. But if you're going to read specifically off something, please tell the court on the other side what you're reading
I
from.
didn't read it verbatim. I just said it was there, and I got
It was where, sir?
in here, and I'm just
What's
looking
in
at
here?
the statement from Nearing. If it's something that is being used to impeach, I will read it. I will give the proper, page number without question, without hesitation, and without pause.
I'm happy.
Thank you.
But my issue is you can't refer to what's said unless it's being done. The rules of evidence are quite clear. You can only refer to what has been said previously for two specific purposes, for impeachment or refreshing recollection. You just can't stand up and start reading or referencing a transcript with nothing foundational. He asked no foundational questions. He goes straight to reading from or paraphrasing a transcript. You can't do that under the rules of evidence. You have to ask some type of foundational question first.
Let me see. We're back at the point where he's reading from the report from Detective Nearing, and he says, did you tell Nearing 3 lemon drops? And then later, and a shot of tequila. And then you, through the rule of completeness, I asked the witness, did you later change it to 2 lemon drops? She said yes. We're on the same page with this.
He went to ask her. He started asking something else that was in the transcript on a different subject, Judge. And that was my objection. And it's not a police report. It's actually a transcription of a audio and video statement of this young lady that he's referring to and reading from.
Judge, can I have five? Can I have 5 minutes?
I think the court could use 5 minutes recess.
Thank you.
Vic and Nancy, would you please make those friends safe and comfortable?
You may be seated.
Thank you.